Interestingly, after our last webinar, what we got as feedback during our survey overwhelmingly was that many of you wanted to learn and understand overall best practices for Medicare secondary payers. So Brendan and I thought, what better than discussing what some of the myths are in MSP and giving you all some best practices to take away. We didn't want to kind of just level set and give you what the truth was and debunk that myth. We want you all to be able to take something back to your respective organizations and be able to implement that guidance accordingly. So we hope that's helpful. And again, long story short, the surveys are super helpful for us for future webinars as to what you all want to hear about. So let's go ahead and get started. So we've got 10 myths to discuss today. Like I said, we're going to kind of go through what the myth is, then we're going to debunk it, and then we're going to tell you a best practice around that MSP scenario. So first, myth number one, and we've heard this for years, that CMS might be bound by your settlement agreement and agreed upon order, right? So assume the scenario where, let's say you are the primary insurance payer, and as part of the settlement agreement, you have designated claimant or plaintiff attorney or the claimant or plaintiff themselves to reimburse Medicare for any past payments, any conditional payments. So the thought process would be that, oh, I'm protected because in my settlement agreement, the claimant, the plaintiff, they're actually going to reimburse Medicare. And in the settlement agreement that a judge signed off on, so I have no responsibility if Medicare does not get reimbursed by the claimant or their attorney. That is a myth, right? Under the regulations pertaining to Medicare secondary payer, Medicare has an absolute right of recovery. Medicare can recover from any party receiving settlement proceeds. Medicare is not bound by your settlement agreements. They can pursue any party. And furthermore, Medicare can pursue up to your settlement amount, but they are capped at the total settlement amount. So that is good. But let's say the situation, like I was explaining earlier, where you've designated the claimant attorney to pay back Medicare or Medicare Advantage plans for conditional payments, and the claimant or claimant attorney does not do so. Medicare can now switch the debtor. They can revert back to the primary insurance payer, and it doesn't matter what your settlement agreement says. You'd have to pay Medicare back. And then certainly if you had indemnification language in your settlement agreement, you could attempt to pursue recovery from the claimant or claimant attorney pursuant to your indemnification agreement, but it's not binding upon Medicare. So again, just know that Medicare is not bound by your settlement agreement. So it's really important to be careful about what goes into settlement documents. And that's why we feel that we have a unique situation here at Sanderson Firm, because we are a law firm. We're able to, in addition to providing the standard Medicare secondary payer compliance services, as Mark mentioned at the beginning of the webinar, we're also able to give legal advice and help our clients craft settlement language, right? So again, hold harmless indemnification language might be effective because of that scenario where I explained before. If the claimant or claimant attorney does not pay and you have to reimburse Medicare, you could then seek to enforce that indemnity agreement in court. So that would certainly be an avenue that you'd want to pursue. Generally, though, we recommend direct payment back to Medicare or Medicare Advantage plans by the primary insurance payer because of the double damages risk exposure, because of the possibility that the claimant or claimant attorney were not to pay and you'd have to step in and pay, right? So for Medicare set-asides, though, it is still a best practice to obtain a court order in the absence of a treating physician statement regarding appropriate future medical care. So I just want to make sure that for the most part, we're discussing here Medicare not being bound by your settlement agreement as it pertains to past payments made by Medicare. Your court orders as it pertains to future medical treatment and MSAs are still a very great idea. And again, that needs to be an evidentiary order, meaning it needs to be an order that's issued after the hearing on the merits of the case. It can't just be the judge agreeing to sign off on what the parties have agreed to and stipulated to. It needs to be an evidentiary finding for that to hold weight. So we have seen this, right? We have seen situations where Medicare has disregarded settlement agreements, has switched the debtor to the primary payer. And so it's something to really be careful with, and knowing that there's absolute liability in Medicare secondary payer.
Okay, so hello everyone. So let's dive into myth number 2. So this is a big one. So myth number 2, Medicare Advantage plans, or MAPs as they are known, have less recovery rights than traditional Medicare. So pretty bold, big misunderstanding or myth here. If you or your organization just happens to believe that this myth is true, and depending on the extreme to which you take this, this could be a pretty costly thing to not be aware of in the form of potentially a lawsuit from a Medicare Advantage plan for not taking their recovery rights seriously. So what we're talking about here is Medicare Advantage plans versus traditional Medicare. So just for those of you who may not be aware, when we talk about traditional Medicare, we're talking about original Medicare. So that means Medicare Parts A and Medicare Part B. So your hospital coverage and your routine, doctor's visits. By contrast, you have private Medicare plans. A Medicare Advantage plan is an example of a private Medicare plan. And these maps actually provide the same, if not more, benefits than traditional Medicare. So in addition to hospital coverage and doctor's coverage, you get, in some instances, visual, hearing, dental care provided by these private plans. So federal courts have actually held that Medicare Advantage plans have the same recovery rights when it comes to recovering their conditional payment lien reimbursement. So if you find yourself in a scenario where you have a settlement or even just a claim involving a Medicare beneficiary, and you know that that individual is involved in or is enrolled in a Medicare Advantage plan, and you know that that Medicare Advantage plan has potentially paid for that beneficiary's treatment, that Medicare Advantage plan is entitled to be reimbursed. And if that Medicare Advantage plan is not timely reimbursed, then under the law, that MAP can actually file a lawsuit in federal court for double damages to pursue recovery for the amounts that weren't timely reimbursed back to it. So this case law has been out there since at least 2012, started with In re Avandia in the Third Circuit. Since then, it spread like wildfire across various circuits nationwide, where essentially you've got many jurisdictions holding that if these private Medicare plans aren't reimbursed, then they can sue you in federal court. And for those of you who either are following or maybe may not be following just the general case law, we see case law come out all the time. And what the case law is showing is that MAPs are suing primary payers for recovery. What you're actually not seeing is traditional Medicare or original Medicare suing these payers for recovery, and probably because the federal government just has tools to its advantage. So they can, use the Department of Treasury and sort of garnish, use a bunch of different tools to seek recovery, whereas these private Medicare plans are not afraid to just instantly, file a lawsuit. And interestingly too, some federal courts have given Medicare Advantage plans a 4-year statute of limitations recovery period. Under the Medicare Secondary Payer Act, the federal government itself, or original Medicare, has 3 years, so 3-year statute of limitations. Some courts have gone beyond that for MAPs and given MAPs a whole additional year. So, I mean, not only is it a myth that Medicare Advantage plans have less recovery rights than traditional Medicare, in some instances, MAPs may have arguably more recovery rights than traditional Medicare. So if we go to best practices on how to combat this myth. So number one, most importantly, treat private Medicare plans, whether that's MAPs or Part C prescription drug plans, with the same level of care, if not more care, than traditional Medicare. Because if you don't, you could be looking at a lawsuit. Number two, if you find yourself, we see this all the time, where a traditional Medicare's lien amount is 0, this is even more reason to check for private Medicare liens. So if you have a settlement involving a Medicare beneficiary, and I get this call all the time. Someone calls me up and say, hey, Brendan, we're all good. I've got this settlement involving a Benny. Medicare's lien is 0, so we've got all this extra money. We don't have to worry about liens at all. I say, wait, hold on. Did you run a search for a private Medicare lien? Because chances are, if they're a Medicare beneficiary, and if original Medicare didn't pay for anything, then probably private Medicare paid for something. So always, as a third bullet point, always check, doesn't matter if you know you're dealing with a Medicare beneficiary, check for both traditional Medicare liens and for private Medicare liens as well.
Yeah, and if I might add as well, regarding the PAID Act, which some of you might have familiar with, the PAID Act was enacted in 2021 and basically forces Medicare to return Medicare Advantage plan, which is known as Medicare Part C, and Medicare Part D enrollment information in the query response file as part of your Section 111 reporting. What we've found here at Sanderson Firm is that some organizations are not looking at the PAID Act data, right? So the enrollment information, you should have that information if you're doing the proper query, which is the first step with the big five information to check if someone's a Medicare beneficiary. We've seen that some certain TPAs and some claim software systems don't pass that Part C and D information back, and so it's not known, or perhaps it's being passed back and not looked at. I know you've seen that, Brendan, as well, right? So that's not only checking for the lien, but look at the query data coming back. And while it's not always 100% accurate, the query data regarding MAP plans, it's a start, right?
Yeah, and just to add on too, in case those of you who may not be aware, roughly half, if not more, maybe just a little more than half of all Medicare beneficiaries are actually enrolled on these private Medicare plans. So it's a large portion of the population.
For sure. And if you all were on our last webinar we had with Brian Bargender, who's the lead subrogation expert for Humana, which is one of the largest Medicare Advantage plans across the country, he had some kind of graph that basically over time in the next 20 years, that number is going to double. So what you're going to find is that more and more of your Medicare beneficiaries are in fact on a Medicare Advantage plan and not on traditional Medicare anymore. And it's only going to increase with time. So this is really a hot area of concern and something to really make sure that your organization is handling properly. I think this is a great segue into Medicare Myth 3, which is Section 111 reporting, right? That electronic data exchange between primary insurance payers and Medicare of settlements and claims with Medicare beneficiaries does not impact conditional payment recovery. That is a huge myth, right? So Medicare's contractors and even the Medicare Advantage plans, they work off of data that they receive through the Section 111 reporting data. So Medicare's conditional payment recovery contractors, the CRC, which handles the workers' compensation and no-fault claims involving ongoing responsibility for medical, and the BCRC, the other contractor at CMS that works with liability claims and also closed or settled workers' compensation claims, they work off of your Section 111 data. So if you report to them a certain settlement amount and a certain ICD codes as being related, they're going to use that data to now drive their conditional payment recoveries. It's really important that you realize that the two are synced up, and that's why you really need to make sure that your data that you're sending to Medicare is accurate, right? So if a responsible reporting entity, so a responsible reporting entity is also known as an RRE, that would be the primary insurance payer that's actually paying benefits to the Medicare beneficiary. If they report incorrect ICD diagnosis codes, Medicare can seek recovery for those codes. So really important to report ongoing responsibility for medical also accurately, right? We see this all the time. And in fact, recently we've been talking about internally at Sanderson we're hearing from a lot of our clients that Medicare is coordinating benefits much more often. And it could be sometimes that Medicare's got it wrong, but a lot of times we're finding that a Medicare beneficiary is being denied care, and it might be for something that's not work related, but if you still have your ORM flag as Y, Medicare is going to deny Medicare treatment to that Medicare beneficiary because they still believe that the primary insurance payer has ongoing responsibility. It's really important to accurately terminate ORM when it's appropriate. And although civil money penalties are not going to be assessed for incorrect coding or flagging of certain codes, it can still result in conditional payment issues. Way back when Medicare was initially discussing civil money penalties for Section 111 reporting, they were going to potentially penalize RREs for improper coding and a conflict between your Section 111 data and your conditional payments. Technically, this is not something that would cause a penalty currently. However, again, it really will impact the conditional payment recoveries that you receive and the coordination of benefits issues like we just discussed. So best practices, make sure that your ICD codes reported to Medicare are as specific and as accurate as possible. It's really important. We've seen some interesting things at some organizations using potentially their bill review data just to automatically populate codes that go over to Medicare. Bad idea, right? Because everything but the kitchen sink is going over to Medicare, and Medicare is going to think everything is part of the claim. You want to really make sure that you're updating the ICD codes not only at the time of settlement, but throughout the life of the claim as to what's accepted. Don't over-report ICD codes simply because they're listed on a medical record. On the other hand, you also don't want to underreport codes, right? We've heard of some claim systems that only have the capability to report one ICD code. So again, it's really important that you're reporting. I think Medicare takes up to, is it 19 codes? Is that right, Brendan?
19, yep.
So yeah, so probably most cases you shouldn't need to be populating 19, but in most scenarios you're probably not really shouldn't be, populating one code. It should be somewhere in the middle, depending on the severity of the injury and what's involved, of course, but really important to make sure your section 11 is accurate. And also on terminating ORM, that is something to be done aggressively and proactively as much as possible, right? If you've got a claim that is no longer open due to statute of limitations, the treatment's concluded, you've closed out medicals, or you meet Medicare's termination criteria of ORM under their reference guide, you definitely want to terminate ORM. Otherwise, you're leaving yourself exposed for additional conditional payments. And again, the Medicare beneficiary is probably going to experience benefits issues and be denied care improperly, which you'll be hearing from them, and you don't necessarily want to have that, right? So
Okay, so myth number 4, move my camera around. Okay, so myth number 4, Section 111 reporting and conditional payment handling responsibilities may be shifted onto the claimant slash plaintiff and their attorney. Okay, so let's kind of take this piece by piece. We're talking about two things here, Section 111 reporting and conditional payment. So let's take the first part. Section 111 reporting responsibilities may be shifted onto the claimant and their attorney. So that is not true. As we'll talk about a little bit later too in the presentation, only RREs, responsible reporting entities, or their agents may report via Section 111. It's actually not even possible for a claimant or a plaintiff to report via Section 111. That structure is really only reserved for insurance carriers or self-insured entities. So how this myth normally comes up to me is I'll be involved in a claim, I'll get a call from an adjuster, and the adjuster will say, hey Brendan, I got word from plaintiff's counsel. Plaintiff actually called Medicare and reported this claim for us. So we're all good on Section 111 reporting. We don't have to do anything, right? And I have to say, no, that's actually not necessarily the case. So when a claimant or a claimant's attorney reports to you that they have, quote unquote, reported a claim to Medicare, what they're actually saying is, hey, we notified Medicare of this ongoing claim or a pending settlement such that Medicare actually opens a conditional payment recovery file. So when they're communicating to Medicare, that's typically through a phone call, and it's either to either the BCRC or the CRC. That's great. That's fine. But that's strictly for the conditional payment component. The Section 111 reporting obligation is an entirely separate component. So just because a claimant calls Medicare to have a conditional payment lien file open doesn't mean that the RRE is absolved from reporting that claim via Section 111 reporting. In fact, if the carrier doesn't also report through Section 111, they're going to be faced with some coordination of benefits issues, and in the future too, some civil money penalty exposure as well. So part one of that myth debunked. The second part is conditional payment handling responsibilities may be shifted onto the claimant slash plaintiff and their attorney. And this is, maybe I'll put like an asterisk here. So this is, as Heather mentioned earlier, this is kind of true, maybe not. Technically, in the settlement agreement itself with a Medicare beneficiary, you can say, have language say, hey, the Medicare beneficiary is going to be responsible for reimbursing Medicare or a private Medicare plan for any and all outstanding liens or government liens, etc. You can write that in there, but guess what? Like Heather said, Medicare is not a party to your settlement, to your agreement. That agreement is obviously between the claimant and the insurance carrier itself. So if that agreement goes south and let's say the claimant breaches and does not reimburse that lien, Medicare has any number of options under the regulations. Medicare can go after the beneficiary themselves for reimbursement. Medicare can go after the attorney for reimbursement. Medicare can go after, obviously, the deep pockets, the insurance carrier. So just keep that in mind. You can shift responsibility via contract or agreement, but when it comes down to it, Medicare can pursue recovery from anyone that it wants. Okay, so best practices here for both parts. So obviously, as it pertains to Section 111 reporting, just recognize that it's the RRE is solely responsible for Section 111 reporting. Number two, if your organization uses a reporting agent for Section 111 reporting, ensure that your reporting agent is consulting with you, providing you with error reports, and reaching out to you for improving compliance. So essentially what this is saying is make sure your reporting agent is playing an active role in the reporting of the claim. It's not honestly really good enough that a reporting agent simply takes your data and tries to feed that through to Medicare Section 111 portal. Your reporting agent should at least be looking at your data, telling you if they see any irregularities, issues, because a bad report, Section 111 report, to Medicare is ultimately going to come back on the actual organization or the RRE itself in terms of fines and penalties. And then lastly here, for conditional payments, if the settlement agreement holds the claimant slash plaintiff responsible for reimbursement of conditional payment liens, you can run your own lien search. So don't just sort of blindly take faith that the claimant is going to reimburse Medicare. You can independently run your own search and verify that those liens have or have not been reimbursed, so there's not any surprises in the future.
Great. I think this is a perfect segue. I didn't even realize this slide was coming up next, but I was thinking about even saying it. So this is perfect because Brendan was talking about making sure that if you're utilizing a reporting agent, that you're getting feedback and oversight on your data. And the reason behind that, and we're saying this so strongly right now, is because Medicare is going to finally start issuing civil money penalties, right? The final rule is done. Let me hit the myth and then I'll dive in and explain it. So the myth says, because the civil money penalty final rule does not become applicable till October 2024, you don't need to worry about your reporting compliance until October of 2024, right? So we've had a lot of clients asking us about this, saying, well, so the final rule has been in place. So for those that are not aware, Medicare issued its final rule last October of 2023, which now allows Medicare to issue penalties. So the rule became law October of 2023. It's applicable as of October 2024, and Medicare is going to prospectively look at non-compliance and untimely reporting of claims and settlements that occur post October of 2024. So that's question has come to us as well. Do we need to clean up our historical data given that Medicare is not going to issue any civil money penalties for any of those pre-October 2024 claims and settlements? So it's true, Medicare will not issue any penalties on any claims or settlements that occur before October of 2024. However, that does not mean you don't need to clean up your historical data, because there is going to be the exposure of the fact that if you don't report a TPOC, the total payment obligation to claim it timely, right? So that's your settlement. You basically are leaving yourself wide open for conditional payments, and Medicare's statute of limitations will not start running until you report that settlement, right? So you're leaving yourself exposed. Furthermore, there's just bad patterns that are in place, right? You want to look at the trends of your data right now and make sure that you're reporting properly, right? So even though that this penalty is not going to come into place for claims and settlements till October of this year, and for those claims and settlements that occur thereafter, really important from a conditional payment standpoint, like I said, and statute of limitations, and secondarily identifying trends. So let me dig a little further into that. We're not only a Section 111 reporting agent, we use a system called Sanderson Comply. We've also had some clients come to us and say, we'd like for you to audit our data just to make sure we're compliant in advance of civil money penalties. So we've done that. We've audited a good number of entities that wanted to know. And a lot of these entities were very Medicare savvy, and we found some interesting things, right? Like one work comp payer didn't know that they needed to report TPOCs. They were only reporting TPOCs on their liability settlements, but not on their work comp settlements. Woo, that's a big issue that we uncovered for them. We found with another client reporting the type of claim wrong. They were reporting it as no fault when it was in fact liability, right? So if we didn't catch these things now, this would continue in perpetuity into the future and certainly cause a penalty. So now is really the time, if y'all are, really wanting to make sure your organization is compliant, to really be thinking about this. Now is the time. Don't wait till October or later. Now is the time to look at it. So there also is a tiered penalty that will come about. In the Federal Register, the rules are listed as $250 per day per claim if the report is 1 year to 2 years late, $500 if the claim is 2 to 3 years reported late, and then $1,000 per day per claim if it's reported more than 3 years late. But really important to note that those amounts are not final. That's what's in the final rule. But these amounts are all subject to inflation. So that $1,000 per day per claim for claims that are reported more than 3 years late is actually at I think it's at like roughly around $1,440 or something. I forget the exact amount, but it's about $1,400. And so every year these penalties are going to increase. Really, now is really the time to make sure that your organization is compliant. We can help if you need help with that. Again, so best practices, timely reporting, right? Because if you report your total payment obligation to claim at your settlement too late, or your ongoing responsibility for medical acceptance too late, you're going to be subject to penalties if it's more than 1 year late. So want to make sure that your organization is reporting ORM and TPOC timely. And again, now is a great time to really look at what you're doing with your Section 11 and make sure that it's compliant. Another thing that we want to make sure to do is that if you've got a situation, particularly with liability claims, we sometimes have Medicare beneficiaries that are reluctant to provide their social security number. You want to make sure that you're documenting those attempts to obtain the social security number in your records, or you can be subject to a penalty. Medicare said in their final rule that responsible reporting entities need to document at least 3 attempts to obtain a person's social security number to be exempt from penalties. Now, the first 2 attempts can be by phone or email, which is nice. I believe email or written mail. That's right. Email or written mail, the first 2 attempts. And then the third attempt can be by phone. It can be by some other reasonable method. And we believe that to be a social security number lookup as well. We also have that service as well. We can look up social security numbers as well. So really important. There's no reason to get dinged for not obtaining a social so long as you've documented your attempts to obtain those.
Okay, so hopping into myth number 6 and really just driving the point home here on just the importance of Section 111 reporting compliance, given that the final rule will become applicable in October of this year. Okay, so myth number 6, if your organization has a reporting agent and your reporting agent mishandles your Section 111 reporting, I guess in other words, incorrectly reports data to Medicare, um, then your reporting agent is subject to the civil money penalties and your organization is absolved. That is not true. When it comes to CMS's position on Section 111 reporting, you can effectively think of it as strict liability. Medicare doesn't care that there was a mistake. Medicare doesn't care the responsible reporting entity's even intent. There could be all the good faith intent compliance in the world there, but ultimately, if you're an RE and you use a reporting agent, and for whatever reason, if that reporting agent messes up and that causes a civil money penalty, then CMS is going to seek direct recovery against the RRE itself, not the recovery agent. And so, as you'll see here, straight out of CMS's NGHP user guide, which is Medicare's official policy guidance on Section 111 reporting compliance, it says, quote, an RRE may not shift its responsibility to report under Section 111 to an agent by contract or otherwise. The RRE remains solely responsible and accountable for complying with CMS instructions for implementing Section 111 and for the accuracy of the data submitted. So if we move on to the next slide, we talk about best practices here. I guess I'll skip to actually let me just start with the third bullet point here. I would definitely, if you're using a reporting vendor now, it's definitely a good idea, given Medicare's strict liability position on penalties. Definitely look at requiring that your reporting vendor retain E&O, errors and omission insurance, because sure, that penalty, if your reporting agent makes an error and Medicare issues a penalty against your organization, at least that's an E&O claim that your organization can pursue on the back end to sort of recover funds based on someone else's negligence or intentional error. So look into that for sure. Also, if your organization is an RE and does not handle its own reporting, obviously select your vendor carefully. Interview them. Don't be afraid to ask them the hard questions. Is there, for example, is their system capable of even handling the reporting of the upcoming work comp MSA information? Obviously, that's coming soon, so you want to make sure that your reporting vendor isn't someone who's stagnant. Make sure that there's constant updates and that it's actually capable of reporting correctly. And then also, this goes back to my point earlier, but ask your reporting vendor for error reports to ensure that your vendor is attempting to track reporting errors. So again, make sure your reporting vendor is taking an active role, because for all you know, maybe your vendor is really just feeding the data through CMS's feed and just has no interest in correcting errors and is just collecting a paycheck and is not performing its function. Your reporting vendor should be helping you avoid penalties, not just play a complicit role in that. So definitely make sure that they're actively giving you error reports and correcting data inconsistencies for you.
Yeah, and if I may, Brendan, I just want to elaborate a little bit on why correcting errors are so important, particularly what Medicare calls hard errors. So someone within your organization might attempt to timely report TPOC and ORM, but if the submission returns a hard error, and let's say you're not getting that error report from your reporting vendor, or maybe you're getting the report, but you're not looking at it, you're not fixing the errors, it's like it was never reported in the first place, which means you're now subject to penalties. So that's different than a soft error. With a soft error, Medicare will still accept the report and you wouldn't be subject to penalties, but correcting your errors are so important just to make sure that the submission goes through and that you're not subject to penalties. So really important there. Okay, let's talk about MSAs. So we've seen this misconception a lot through the years, Brendan, right? People that kind of look at Medicare's workload review thresholds for review of an MSA and believe that to be the gospel, or the reasoning and the criteria around when you need an MSA, right? And that is a complete myth. These are workload thresholds. Medicare's review contractor, the WCRC, cannot possibly review every single MSA, which is why they've put into place workload thresholds. But Medicare has been clear all through the years, ever since they started reviewing MSAs in 2001, that these are simply workload thresholds. They are not safe harbors. And so let's talk about that, right? So Medicare's workload review thresholds for review of an MSA, which, by the way, the Medicare review process of an MSA is completely voluntary, always has been and always will be until Medicare changes the law. But the criteria are: you have someone that's a Medicare beneficiary and the total settlement amount is greater than $25,000. Medicare will review an MSA in that situation. Or the claimant has a reasonable expectation of Medicare enrollment within 30 months of the settlement date, and the anticipated total settlement amount is greater than $250,000. So those are the thresholds, but that just because you have, let's say, a claimant with a reasonable expectation and your settlement is $200,000, that doesn't mean you don't need an MSA. Or similarly, if you've got a settlement that's $20,000 and the person's on Medicare, you still probably need an MSA. Again, these workload thresholds do not apply to when you need an MSA. It's just when CMS might potentially would look at the MSA if submitted. So there's an example in the WCMSA reference guide, and it says, a recent retiree age 67 eligible for Medicare benefits under Part A, B, and D, files a work comp claim against their former employer for a back injury sustained shortly before the retirement that requires future medical care. And here's an example of where Medicare is saying you still need an MSA even though it's below threshold. Basically, they're offering to settle the claim for $17,000. And so what CMS says is that this person is going to require future care. They're going to require this anti-inflammatory drug for the balance of their life. And what Medicare says in the guide is that the settling parties must consider CMS's future interest, even though the case would not be eligible for review. And failure to establish an MSA could leave the settling parties subject to future recoveries for payments up to the total value of the settlement. So really happy to debunk that myth. And I think one thing that I hope none of you do this on the call, but one of my biggest pet peeves is when people try to settle their case for $24,999. One of my biggest pet peeves in the world, and first of all, you got to remember that that settlement amount is being reported to Medicare via Section 11. If you want to put a red flag on a file, that's one way to do it. And you don't need to do that because number one, again, the workload review thresholds don't dictate when an MSA is needed. And even if your settlement was $1 more and was $25,000 or greater, you don't have to submit the MSA to CMS. It is a voluntary process. So you definitely want to look at having an MSA in your settlement, regardless of whether you're submitting and regardless of the workload review thresholds. If you've got someone who's currently on Medicare, reasonably expected to be on Medicare, you're settling out future medical, and the person's going to require future care that might be otherwise covered by Medicare and is claim related. And again, if you have someone that is objecting to having a Medicare set aside, you certainly want to document that objection in the settlement paperwork, because without an MSA, basically Medicare can deny care up to the total settlement amount. Now, that's the benefit of the MSA, right? Is that generally in Medicare's regulations, it says that to the extent a portion of the settlement is carved out for future medical, such as the MSA, Medicare will only coordinate benefits as it relates to that future medical component and not the whole settlement. If you don't designate an MSA and you don't designate a portion of the settlement for future medical, Medicare can deny care to the Medicare beneficiary up to the entire settlement amount. So really important to know when to have an MSA. Feel free to call on us if you have a question when an MSA is appropriate. But again, please don't look at the workload review thresholds from CMS as to when you might need an MSA or not.
And that's a great segue into myth number 8. So myth number 8, if CMS disagrees with a non-submit Medicare set-aside, CMS may deny that Medicare beneficiary's benefits up to any amount and also seek direct reimbursement from the primary payer itself. So as Heather just mentioned, as mentioned in other slides, Medicare's total recovery is capped at the total settlement amount itself, pursuant to 42 CFR 411.37. So if we have a scenario where, let's say you have a workers' compensation claim, it involves a Medicare beneficiary, and that, let's say it's settling for $100,000, inclusive of a $30,000 non-submit evidence-based MSA. That $30,000 has already been funded. So assuming that amount exhausts and Medicare deems that that allocation amount should have been higher, Medicare can only deny treatment up to the remaining total settlement amount itself. So that's the $100,000, the difference. So in this example, Medicare could deny benefits up to $70,000. So I think maybe part of the reason why people or some individuals may be uncomfortable with non-submit MSAs is they may say, okay, well, since Medicare isn't issuing a position on the appropriate allocation amount upfront, what if down the line, 1-2 years, Medicare comes back and says, no, in this scenario, it shouldn't have been a $30,000 non-submit MSA. It should have been a $3 million MSA. Medicare can't do that. Medicare is not going to penalize the Medicare beneficiary for maybe taking a settlement that isn't, I guess, fair, right? So regardless of if the allocation is submitted or not submitted, Medicare's total recovery is limited to the total settlement amount itself. Also, to date, there are no known challenges in the industry by CMS, either against a beneficiary or primary payer, holding that a non-submit allocation amount shouldn't have been used, or that a non-submit Medicare set-aside amount just wasn't sufficient enough to protect Medicare's interests. I welcome anyone in the chat. If you know of any examples, please feel free to share. But I'm certainly, and I don't think Heather is not aware of any instances of CMS calling into question a non-submit allocation. And then lastly, just things to keep in mind. If using a non-submit MSA, parties should ensure that that non-submit MSA was prepared in accordance with CMS guidelines and includes reasonable medical care. So obviously, if you find yourself in a scenario where you have a non-submit MSA, a couple years passes, Medicare files a claim, you want to make sure that that allocation was at the very least, medically appropriate. So if that non-submit was based on evidence-based medicine, and hopefully that allocation was prepared by a licensed clinical nurse, such as we have at Sanderson Firm. So professional who has meticulously combed through the medical records and with some professional certainty can confirm that this is the appropriate amount of medical care that that person would reasonably need for the rest of their life should CMS challenge it in the future. So best practices just generally on non-submits is one, you probably want to make sure that your non-submit MSA vendor defends and indemnifies the allocation. And what I mean by that is if CMS down the line brings a claim, not only will that vendor defend that allocation to, let's say, an administrative law judge and sort of lay out why it's protective of Medicare's interests, you also want that vendor to indemnify the allocation, meaning obviously that Medicare beneficiary is going to have their benefits temporarily suspended. So someone's got to pay. And if your allocation is indemnified, that MSA vendor would actually pay for that individual's claim-related Medicare covered treatment. That way, the beneficiary is protected in the defense and with the indemnification, and there are no leaks, so to speak, in the actual coverage itself. Which is, by the way, something that Sanderson Firm does with our defense indemnification program on all of our non-submit allocations. Number two, ask your non-submit vendor which party or parties the indemnification applies to. We're certainly aware of some vendors in the space who are selective in choosing who the indemnification applies to. Maybe they are only indemnifying the claimant, or maybe they are only indemnifying, I don't know, one of the attorneys. Kind of ridiculous, not entirely fair to the settling party since everyone kind of shares in the exposure overall. So ask that question, and ideally you want to find yourself a vendor such as Sanderson Firm who actually indemnifies and defends all parties to the settlement. And then lastly, ask your non-submit MSA vendor whether there are any restrictions or contingencies with securing the indemnification itself. For example, I am aware of, I think maybe one or two vendors in the space who require that in order to indemnify a non-submit allocation that they prepare, they require that that Medicare set aside is, I don't know, either annuitized or professionally administered. There's some sort of contingency. At least with Sanderson Firm, there are no such crazy restrictive contingencies on when the indemnification will actually apply.
Okay, so some of you might have heard the recent news that as of April of 2025, Medicare is now going to be requiring Medicare set-aside information be reported as part of Section 111, right? So that electronic data interchange with Medicare, there's now going to be fields related to MSAs. This is certainly new and interesting development because we've had Medicare set-asides in existence since 2001. Reporting via Section 11 has been in place since 2010, but never has Medicare actually asked for the MSA information to be reported in a Section 111. So a myth that we're hearing, and we believe it to be entirely not true, is that Medicare has specifically implemented this new Section 111 requirement of reporting of work comp MSAs as a way to attack or challenge non-submit evidence-based Medicare set-asides. And that's not the case. Medicare has been very clear. The upcoming MSA reporting requirement is due to coordination of benefits issues and a lack of communication of final settlement to CMS by settling parties. So we actually asked CMS this. If you've actually approved an MSA, the WCRC has actually approved an MSA, why do you then need it again reported as part of the Section 111? And what Medicare said was, a lot of times what happens is they approve an MSA, and then what they're supposed to get is a copy of the finalized settlement document so that the parties have told Medicare and communicated that they've actually settled and they've actually funded the CMS approved MSA. Otherwise, CMS doesn't know what's happening, right? They don't know when settlement occurs, right? And so they need to know that in fact the MSA was funded. So this is just closing the information gap for them so that they can properly note in the claimant's common working file that there is an MSA amount so that they're not paying when the MSA should pay. But again, they did acknowledge during their recent webinars again that they not only want submitted MSAs reported, they want non-submit MSAs reported. They're treated just the same, right? It's an MSA that's designed to provide for that future medical care, and Medicare wants to know that the MSA is in place and that the claim has settled. So this is certainly a myth. Medicare is not trying to attack non-submit MSAs. This is simply a coordination of benefit issues. And so regarding MSA reporting coming up in about a year from now, this should not change how your organization approaches MSAs, whether you like non-submit MSAs or submitted MSAs. They're both still allowed under the law, both are legally permissible. And as Brendan spoke about in great depth on the last myth, if you have a great Medicare set aside program that's fully indemnified, the non-submit MSA is prepared meticulously and is fully defensible, then there's no reason to remain concerned. And again, the reasoning for whether to obtain an MSA remains the same. And for settlements involving Medicare beneficiaries where no amount will be set aside for future medical and there's a valid basis for this, such as a zero MSA, CMS will agree with the zero MSA and is generally not going to question it.
Okay, and I'll cover the last myth here relatively quickly, given that we have 10 minutes, and I see we have at least some questions in the chat. Okay, so myth number 10, sticking on the theme of non-submit Medicare set-asides. So non-submit or slash evidence-based MSAs are not supported by CMS slash are not legitimate. So I guess two things here, two myths and one. One being that just the fact that an allocation is not submitted to CMS means it's not legit, or the fact that an allocation is based on evidence-based medicine makes the allocation not legit or not supported by CMS. Both are false. So just number one, overall, according to federal regs support this idea, the concept that settlement agreements allocating for a specific amount for future medical services, which protects the rest of our settlement funds outside of future medical care. Essentially, what this is saying is, if you are a party to an agreement and you clearly defined an amount of the settlement to be set aside for future medicals, the settlement dollars themselves are protected from CMS recovery. Number two, in terms of just the act of not submitting an allocation to CMS generally, the WCMSA reference guide itself, which is Medicare calls it the Bible, it's their only written policy guidance on the appropriateness of work comp MSAs. In that reference guide, it confirms that there are no statutory or regulatory provisions requiring the parties to submit an allocation to CMS. So Heather went over the submission slash workload review thresholds earlier. Even if those review thresholds are met, still, that does not mean you have to submit that allocation to CMS. Speaking to the idea of using evidence-based medicine in your MSAs itself, that is also fine as well. There are actually two references in the WCMSA reference guide where Medicare itself confirms that the WCRC, the work comp review contractor in reviewing submitted MSAs, actually itself relies upon evidence-based guidelines for determining the appropriateness of medical treatment. And then lastly, real quick here, some of you may be aware of more than 2 years ago at this point, where CMS for the first time ever formally acknowledged in writing non-submit evidence-based MSAs. That caused a huge stir in the industry, where Medicare effectively said, if the parties are using a non-submit allocation, we, Medicare, can't be assured that the parties aren't shifting the burden onto us, the federal government. So if a non-submit is used, then we, Medicare, will deem that to be an automatic burden shift to the federal government. Caused a huge issue. There was a town hall after that. There were multiple revisions to the WCMSA reference guide itself, and Medicare very obviously uh, couldn't do that and back softened its language to confirm that, hey, no, Medicare is only going to deny benefits on a non-submit MSA if one, that allocation, wasn't prepared appropriately or funded appropriately with enough money in the first place, or two, the Medicare set aside funds weren't used properly, right? So that myth that CMS does not allow non-submit evidence-based MSAs has been completely debunked, and it's been debunked in writing by CMS. Best practices here, really just a rehash of a prior slide. When you're dealing with non-submits, make sure your MSA vendor defends and indemnifies the allocation, is as protective as possible to all the parties, and make sure you double check whatever restrictions or contingencies there are to you actually securing indemnification of the MSA.
Great. So Mark mentioned our various services at the beginning. I'm not gonna go through them again because we have limited time. I don't want to take questions, but I do want to highlight one new offering that we launched. Brendan and I we launched the Medicare Secondary Payer Accreditation. This is a joint venture between Sanderson Firm and Work Comp College. It's a new MSP certification. It's fully virtual. It's online. It's all taught by Sanderson Firm faculty, such as myself and Brendan and several other Sanderson Firm employees. It includes 9 modules that are about an hour long and a final exam at the end. The beautiful thing about it is that you can take it from the comfort of your home. You can take it at your own pace. You can do it all in one weekend. You can do it in one day if you'd like. And it's the latest and greatest. We've had dozens of individuals signing up at many different insurance payers across the country. We're getting great feedback. We plan to do future iterations of it. It's something that's going to keep evolving. We do believe it's the best certification out there. If you have questions on it, please reach out. I do want to share, if you could see on camera, I got to move my hair. This is a lovely MSPA pin. Mark has his on too, that you'll receive after you receive your MSPA accreditation, right? You've got some new fun letters to add to your signature line. We will also send you, if you could see this kind of with my background, it's a nice like certificate that you will get, and it will give you, if I'm not sure if you all can see this, but a lovely certificate that you'll receive in the mail along with your PIN, and you'll have direct access to myself and Brendan and the other Sanderson Firm faculty for MSPA. So just wanted to share a bit about that. We're excited about the momentum we have there with that program, and we truly love educating. Obviously, this is a passion of mine and Brendan. We're going to continue to do these webinars as well. So if you enjoyed today, like I said in the beginning, please do log on to the survey, ask your questions, and let us know what you want to hear about in the future. I'm sure we're going to do another webinar over the summer as well in the next month or so.
And, just if I
Yeah,
could add, and
sure.
check out, did you say this already? Check out the our LinkedIn page. There's a current giveaway going on right now. We're giving away 2 free scholarships or courses for those who are interested in taking the MSPA course. So if you have LinkedIn, check the MSPA LinkedIn page. There's more details there.
That's right. That's right. Mark, I know we've got some of these are pretty hefty questions here, but maybe you can pick a few and read them out loud and send them over to us.
Yeah, absolutely. Just by the way, if you are an anonymous attendee, we don't know how to get a hold of you. So if your question is not answered, we would need to make sure that you can get in touch with us so we can answer. Real quick, how do you identify a map carrier and request a lien if there's no map information available? How do you know what company to contact and how?
Yeah, so as we talked about earlier, I mean, the Medicare Advantage enrollment information should be coming back to you in your query response file from Medicare, right? So when you're querying Medicare status as part of Section 11, you should be getting that information. As we mentioned, it's not always accurate, and you do need to double check with the Medicare beneficiary. We do recommend you verify with the Medicare beneficiary any Medicare Advantage plans they've been enrolled in since the inception of the claim. Sometimes these individuals have been on a multitude of plans, and there's several of them to contact and resolve the Medicare Advantage plan lien. Would you add anything else there beside really kind of verifying with the Medicare beneficiary and as far as the query information, Brendan? Anything I'm not thinking of?
Yeah, I would say unfortunately those are the only options right now. If the PAYDAC data is inaccurate, definitely reach out to the individual claimant, or if they're a rep, their attorney, send them a form, have them confirm which potentially which Medicare Advantage plans they are enrolled in. Maybe if you want, go a step further, add some sort of clause in the settlement document confirming that you sent them this form, asking them to confirm their Medicare information, just so if there's an issue with a lien in the future, you have some sort of defense where, hey, we did everything we could, but we just couldn't find or identify the lien.
Great. Next question. What do we do with claims where we cannot terminate ORM? We have claimants call saying that they are denied treatment or payment of treatment because of an open work comp claim. The current treatment is not related to the work injury, but they are still being denied treatment or payment of the treatment. Any recommendations?
So I would just say real quickly here, depending on the amount of time that has passed, there could either be, if there's not already a statute of limitations defense where you can terminate ORM, maybe it's been 5 years and there's been less than $25,000 paid out. There also exists that separate basis to terminate ORM. So essentially, if enough time has passed, you can terminate ORM. If enough time hasn't passed, I'm not quite sure what you could do about that, because obviously, well, here, if it's recovery that Medicare is seeking based on ORM, make sure, I guess most obviously, make sure that the ICD codes that you're reporting are only for injuries that are actually related to the claim. If you're reporting a bunch of codes that are not related, then Medicare is just going to keep pursuing recovery for those unrelated claims.
Yeah, I think that's a great point. What we find a lot of situations, like Brendan just said, where Medicare is denying for unrelated treatment, it's typically because the responsible reporting entity has reported a code that's not related, and that's why Medicare is blocking payment for it. So it involves no longer reporting ORM for that unrelated code and cleaning that up. But there are certain situations, unfortunately, where you're just never going to be able to terminate ORM, right? Lifetime medical states such as Texas. There's just certain situations where you're never going to be able to terminate ORM, but if you make sure that your coding is up to date and accurate, then that should fix things. And we're happy to help at any point in time. But I think we're at the top of the hour. I know we still have some questions. If you're not if you didn't write your question anonymously, we will make sure to get back to you. But to the extent I see a few questions that are anonymous, and like you said, Mark, we're not sure who they are, how to get them an answer. So
Yeah, absolutely. So if you will reach out to Heather at sandersoncomp.com or Brendan at sandersoncomp.com and identify yourself, and we will make sure for Bridget and others, Amy, Colleen, we're sorry we missed your questions due to time, and we'll definitely get those responses back to you. We thank you for joining this webinar. It was exciting, and we can't wait to see you for the next one. Until then, have a great day, and we'll see you soon.